Welcome. Let's take a look at our big story this hour. As governments around the world ramp up surveillance tools in the name of national security, a landmark ruling by the European Union's top court has come in favour of privacy rights activists. The outcome of the ruling is likely to serve as a precedent within the EU and beyond, in ongoing cases worldwide and in the broader fight to secure individual privacy against state surveillance. The EU's Court of Justice said that the general indiscriminate retention of such data can only be allowed when governments face a quote-unquote serious threat to national security. The court further says that in this kind of situation, full access to phone and internet users' data should be limited to a period that is quote-unquote strictly necessary. Its statement further reads, and I quote again, "Such an interference with fundamental rights must be accompanied by effective safeguards and be reviewed by a court or by an independent administrative authority." Now, the ruling is the result of 4 cases in France, Belgium and Britain, in which governments have called for the extension of surveillance tools for the protection of their citizens. The EU court goes on to warn national courts within Europe not to take into account information collected by authorities that fail to follow the principles stated in the ruling. However, what constitutes as serious threats to national security depends on the state's interpretation. Now, under the ruling, people seriously suspected of involvement in terrorist activities can be spied on and followed online in real time. Mass surveillance tools can be used beyond a set time limit if the threat persists. The Luxembourg-based jurisdiction's decision comes at a crucial time for EU institutions, which are in the midst of preparing a new version of e-privacy directive, which defines privacy rights with regards to electronic communications. Lucy Hughes joins us live from Brussels for more on this. Good evening to you, Lucy. Thanks for being with us. Now, unchecked access to phone and internet users' data can only be allowed when governments face a serious threat to national security. This is a landmark ruling.
This is a landmark ruling, and as you say, it has major implications not just for EU member states, but also beyond that around the world. Essentially, this case was looking at the data practices of 3 countries, Britain, France and Belgium, whose data practices were being queried by the courts as to whether they overstepped privacy laws. And essentially, the court has handed back a decision saying that indeed they do. This is a concern from privacy campaigners about the extent of surveillance powers of police and security agencies. And instead, this means that governments can only ask service providers to collect all data from their customers when there is a serious security of threat. So it is a major ruling, one that has major implications, particularly for the UK, who is now no longer automatically in step with EU law, which could have major implications on the data flow from January the 1st when the UK leaves the EU.
Right, you have touched on this. What constitutes a serious threat to national security, of course, depends on the state's interpretation of that. How are they going to be dealing with this?
Well, as you say, it's a national competence, so it's up for individual countries to define what that is, and that means there is likely to be some discrepancy on how this is applied across the EU 27. We know that countries like the UK and France had justified mass surveillance and data harvesting because of the security threat, but there has been concern since the Edward Snowden revelations back in 2014 about surveillance powers overriding or becoming more than the privacy laws would allow for. So this is about individual countries deciding what threat there is, but the EU law has been clear that EU countries are not allowed to mass harvest data from all customers if they are outside of a situation when there is a serious security threat.
Right, Lucy, such interference with fundamental rights, they say, must be accompanied by the effective safeguards, as we've said, and must be reviewed by a court. But just how big a step is this in terms of privacy rights for the citizens of the EU?
Well, it is a major victory in the courts for privacy campaigners who've been long fighting for this, and a ruling that has huge implications for EU nations. But I touched on earlier, particularly the UK. The UK was hoping to have access to keep the data taps open from the beginning of the new era in EU-UK relations as the UK comes out of the transition period on December the 31st and goes into a sort of full Brexit from January the 1st. But what this does is mean that the UK is out of sync with EU law, so that could potentially majorly impede the UK's ability to access EU data for security purposes. But certainly the EU is concerned about if the UK has access to EU data, what it might do with that, whether it would share it with third parties. So particularly for the UK, it will now have to look at whether it means that it has to now comply with EU law in terms of the data that it harvests and its data practices to ensure that they do comply, or whether it decides to go it alone and therefore have limited access to EU data, which could come in enormously helpful in the event of a security threat, as we mentioned earlier.
Absolutely, Lucy. Thank you very much for bringing us all the latest there. Of course, the latest in the e-privacy directive in that judgment.